is disabled in any way, and may at some point end up receiving any sort of government benefit from, Medicaid, for example, is really one of the main ones that people would be dealing with. There are certain things that people do and they are thinking that it won't cause any issues, or they're maybe just not, they wouldn't think that they would cause issues under any circumstance, that end up causing a lot of problems for the person receiving care, in particular for qualification for those benefits as well. So that is something that we try to get ahead of people doing these things, so that people don't unnecessarily run into problems, or run into problems when it's either too late to fix the problem, or it is very difficult to undo the problem, and you're in a position where that person needs care now and they don't have the funds to pay for it, but are also not getting the benefits they need. So welcome again. I'm Justin Randall. I'm an attorney here with Hooper Law Office. And again, our topic today is common caregiver mistakes. And so one of the materials that, if you signed up in advance for this webinar, that you'll be emailed by us, is the top 10 caregiver mistakes. It's kind of a handy little cheat sheet of, hey, here are the things that people commonly do that can create a lot of issues. And I'll kind of run through some of these today as well. Just a couple quick reminders are, if you're participating via Zoom, you can ask questions, participate by asking questions in the Q&A function. I'll see them pop up, and I will try to get to them as they come up. And if you have signed up via Zoom and signed up in advance, you will be receiving an email from us after this with the top 10 caregiver mistakes, as well as a feedback form. That feedback form is where you can also mark that you would like us to reach out to you to set up an initial consultation. If anything that we talk about today, creates any or raises any concern that you might want addressed. Those are usually set up, those initial consultations are usually scheduled for about 2 hours or so. They are complimentary, they don't cost you anything. We can't really know what we need to do for somebody until they come in and talk to us. So that's, no charge to come in and talk to us for that initial consultation. So if that is something you'd like us to reach out to you to set up, that's where that feedback form is very helpful. But okay, so to get started today, what we are, like I said, what we're talking about is the common caregiver mistakes that people accidentally end up, either doing while they're providing care for a loved one, or maybe were intentionally engaging in the action, but not realizing that action creates a problem for that person's care later on. And the reason some of these create problems for the person who is receiving care, or may end up receiving care in a facility later on, is because of the ways that they interact with benefits that they may need in order to pay for care. So commonly, one of the biggest mistakes that people, and this is the one that tends to create some of the biggest problems, is a child of somebody will be the caregiver, right? And they may be paid by the parents to provide care for them. The problem is when you are paying a loved one to provide care for you, if you do not have the proper agreement in place beforehand, those payments that you were making to a loved one, those actually create what's called a divestment for Medicaid. So if you then need care and you need Medicaid to provide for long-term care, and long-term care being, skilled nursing facilities or assisted living facilities, if you need Medicaid to help provide for that care, you've been continuously, over the 5 years preceding that application for benefits, if you've been paying a loved one or paying somebody for care without the proper agreement in place, then that can be counted against you. And based off of the amount that was paid out over those years, that's how long you'll have to wait before you will actually receive any benefits from Medicaid. So what you have to do if you are, so if you're the child providing care and you are being paid by your parent, or if you are somebody who may need care soon yourself and are thinking about paying a loved one to come into the home and provide care, what you need to have in place before you can actually do this without creating a problem is what's called a caregiver agreement. So a caregiver agreement is, essentially a contract of employment in some terms, where you're saying, I am paying this person to come into my home, provide care. I'm paying them this wage, and it has to be a signed notarized contract. They cannot be retroactive. So if you've already been paying somebody to come into your home and provide care, loved one, family member, close friend, somebody essentially that is not a caregiving organization, right? Then you can't retroactively apply this. So you may have already created that issue, but it's something going forward you can prevent creating more of an issue later on. If it's something you are thinking about doing, then it's good to get this kind of caregiver agreement in place before any payments are being made. So the reason that this is so important, if you are providing care for someone, is you want, if you are paying someone for care, I should say, you want to pay them for their care because they may be taking time off of work to help you out. They may be losing income from other sources in order to take care of you. But the problem with that is if you are not doing this properly, then you will create issues for Medicaid benefits down the road. So one thing to remember with this as well is if you are the caregiver and you're the one being paid, this does count as taxable income. So you do still have to report this on your, your filing of your income taxes every year. It's not just free money in that sense where you're not paying taxes on it. So that can create problems on the caregiver side if they're not careful as well. So it is taxable income, but it's a way that you can prevent a loss of benefits later on for the loved one's care. Okay, so and that was actually our second mistake, is not filing, claiming it on your income taxes as the caregiver. Another part of these agreements that people often misunderstand is that you can't do lump sum payments. So this isn't something where you could have your parent give you $100,000 ahead of time and say, well, this is for my care for the next X number of years. You have to do it as the care is being provided. So it has to be based on like an hourly rate and on the number of hours that you've provided care. And you have to keep records of that in case anyone ever questions it, right? You want to make sure that you're proving and you have the proof available to prevent any sort of disruption to long-term care benefits down the road. So no lump sum payments at the beginning, no lump sum payments at the end. If that were to occur, that would not be valid by the terms of a caregiver agreement. That would create problems for things like, applying for Medicaid. You want to just be careful about how you're doing this. And this is why it's really important to talk with an elder law attorney and somebody who primarily focuses in elder law or estate planning and elder law, in order to make sure that this is set up properly if you're even thinking about doing this. One kind of moving beyond that a little bit is one big mistake, and it's a mistake more in the fact that you're just not guaranteeing that your intended result will occur. But people often say, oh, I'll give you more of a percentage of my estate in exchange for the care you've provided. So if it's a son or a daughter providing care, you might, the thought behind this is usually, oh, I'll increase their percentage. So maybe it's not, an equal split anymore. Maybe they're getting a higher percentage by like 5 to 10% in order to compensate them for the care they've given to me over my life. The reason that this is not ideal or not even guaranteed is because if this is how you're intending for that person to be paid, and you do actually want them to be paid, you're by no means guaranteeing that it will happen. If you are giving someone a share of the estate, there has to be an estate to give them any share of. There has to be assets left for that to occur. And even if there are assets left, if it was not the amount that you thought they might receive, maybe you're undervaluing what their care is, or you're giving them less than they should have received for providing that care. This can occur for a number of reasons, right? I mean, sometimes people just have debt that exceeds the value of their estate, and those creditors have a first right to go and take any assets if they have any claim against the estate. The biggest one, though, is that if you end up receiving any sort of Medicaid assistance for long-term care, in Wisconsin, we have a program called estate recovery, and that is where Medicaid comes in as a creditor of the estate to, receive compensation for the care they've paid for, right? So they keep a running tab on how much they've provided for your care, and they have a way to claim that against an estate. There are certain exceptions to this type of estate recovery. depending on the type of estate plan you have. But for a lot of people who are doing this type of, oh, I'll promise you a certain percentage of my estate, aren't the types of, they're not in a situation where they would have this type of planning done. It would be somebody maybe who, I have a will and I'm going to increase the share of the will that you get, or I have a revocable trust and I'm going to increase the share of that you get, or increase the beneficiary designation percentage, something like that. One of the exceptions to estate recovery, something that does protect against estate recovery, is if you have an irrevocable trust-based estate plan, that is exempt from estate recovery. So unless you have that type of planning in place, using the share of the estate to have any sort of, compensation given, you're not guaranteeing that it's going to happen. So it's better to pay someone through a caregiver agreement and actually provide that compensation to them as it's occurring, for making sure that they get paid what you intended them to get paid for the care they've provided, but also making sure that you're not creating an issue for yourself as the person receiving care, so that you don't have a Medicaid problem down the road. So one of the other sort of kind of tangents of this is when someone tries to gift the home as payment for the care. So a parent says, "Oh, I'll put the home in your name so that that's your payment for providing me care." And this is just like anything else, unless you meet a certain number of very minute exceptions, this can count as well as a divestment for Medicaid. So if that caregiver child is not, not, for example, also a resident of the home, that can create an issue. If you are not going to a skilled nursing facility, this is not an exception that you can use. So if you're going to an assisted living facility, for example, it's not an exception you can use. So if you are gifting the home to the child, that is very likely in a lot of cases still going to count as a divestment for Medicaid. So you don't want to gift the home as payment either. You still want to use this caregiver agreement exception, having that set up properly to pay for that care, rather than these sort of workarounds that people try to enact that end up just creating problems. Another sort of side reason, not directly related to this, but another reason that gifting the home to the children or putting it in their names is just a dangerous thing to do for a number of reasons is, one, and hopefully your kids wouldn't do this, but putting the home in their name, they are now the owner. So that means that if they wanted to evict the tenants, in this case they could, right? So hopefully that would never happen, but it could, and that's the scary side of that. Now, even if that's not the concern, though, the bigger concern is that you are opening up the home, in this case, to the liabilities of that child. When you own your home and you are the main resident of that home, well, if you get sued for some reason, or you have to file for bankruptcy, any of these sorts of issues that can come up in anybody's life, you have some protection over your home as an asset, so that you don't, these creditors can't force you to be homeless necessarily, or nobody can sue you into homelessness. It's meant to protect the person who owns that home a little bit. But if you own a property or piece of real estate and you are not the resident of it, so in this case, if your kids are the owners by name of the home but are living in their own property still, if they were sued for any reason, or if they got divorced, or they passed away, or if they filed for bankruptcy due to like a medical debt or something like that, your home is potentially at risk for their liabilities. So the idea that people have behind this type of planning is, oh, well, if I gift the home to the kids, maybe I'm providing them compensation for care, but maybe I'm also protecting it from my long-term care expenses as well. But you might protect it from your long-term care expenses if you did it more than 5 years before you applied for Medicaid. But you might also be opening it up to a whole host of other liabilities that now outnumber what your initial liability was. So it's creating more problems than it's fixing in that circumstance. A kind of a tax reason behind why this is a bad idea generally is, in a lot of cases, somebody might have lived in their home for 20, 30 years, right? By the time they've gifted this over to their kids. And when you gift property, real estate to somebody, you have what's called a cost basis in your home. It's essentially, this is a huge oversimplification, but it's essentially how much you bought the home for, right? And if you bought your home 30 years ago for a set price and it's now grown in value exponentially, or considerably anyway, and you gift that property over to your kids, there's potentially a huge disparity between that cost basis and what it would sell for today on the market. When you are the resident of your home and you sell it, you have an exclusion from capital gains tax of up to $250,000 per person in that home. So per owner of the home. So as a married couple, that's $500,000, right? But if your kids are not the residents of the home, they don't get that exclusion. So that means that they might have a considerable amount of capital gains tax to pay on that sale. The better way to get the home to them to avoid that issue is to have it pass through an estate plan, because when someone owns that property under current law anyway, when they pass away, that cost basis gets adjusted to fair market value. So up or down, depending on what the current fair market value is. So it avoids, or it eliminates any negative tax consequences in the terms of, having to pay capital gains tax on the sale for your kids. But gifting it over doesn't, creates that issue and does not, benefit them in any way from a tax perspective. Okay, so another really common thing we'll see is somebody will start to pay for the expenses of the caregiver as compensation for the care they're providing. So this would include things like, I'm going to buy your groceries for you, or I'm going to give you money for gas. Or you could think of a number of ways that this might occur, right? The reason that this creates a problem is because that, just like a lot of the things we've mentioned, does count as a divestment for Medicaid and can create a penalty for you. It's one thing when somebody is paying for their own groceries, their own, services in exchange for payment. That isn't a divestment because you're getting something in exchange. But when you start to do that for someone else, that counts as a gift, which is why it creates an issue for Medicaid as well. And another kind of side note to that is you also don't want to, pay them cash under the table to do this, because when you apply for Medicaid, you may and likely will have to provide bank statements. And if they see over the last 5 years these sort of continuous withdrawals from the bank that don't explain where the money went, it doesn't say, I paid festival foods for this, that's where my credit card was used or my debit card was used. It just shows like $100 every week or something like that, just being withdrawn in cash. That's a problem, because you have to explain where that money went then. And if you can't, Medicaid assumes that it was a divestment. It's kind of the opposite of what you would hope in terms of like the justice system, right? Where you're innocent until proven guilty. In this case, it's you are guilty until proven innocent by yourself. So you bear the burden of that. So it's why if you are, paying for your own groceries, or even if you are giving money to a caregiving child to buy your groceries, you still want them to either have like a power of attorney for finance and take your card to the grocery store in order to buy those foods, so that you can at least, trace that back. Again, you still don't want to do that in order to pay for their foods necessarily, or their groceries, but if you are paying them to then go get your groceries, make sure it's being done in a traceable manner like that. Okay, so this is another common question we have where, so what happens if I pay my spouse? I'm paying my spouse to provide care. I'm getting all the assets into their name so that it isn't counted against me for long-term care purposes. The reason that this creates an issue, or doesn't really create the issue, but doesn't fix the problem, is in Wisconsin and in most states where that use Medicaid as sort of their overarching long-term care system, they count the assets of both spouses together. So regardless of whether it's just in your name or just in your spouse's name, without certain exceptions anyway, most assets, regardless of whose name they're in, are counted against both spouses. So even if everything was, given over to John Smith, but I guess come up with a name, Diana Smith or something like that needed care, well, John Smith's assets are still going to count against Diana. So you want to make sure that you are, you're not doing that as a way, thinking you're protecting anything when you're just changing whose name it's in, but you're not actually getting anything protected. So that does not protect you from anything. It's not a way to protect assets. The danger of this is not so much that you will actually create a divestment, because when you give everything to a spouse, there's unlimited gifting between spouses. And the reason that's not a problem for Medicaid is because they count the assets of both spouses. So you want to make sure that you're not relying on this, though. This is the danger. You don't want to rely on this as a strategy and then create a problem down the road, having all of these assets still totally available for care. I mentioned one of these already. Again, paying in cash is not a way to avoid it being noticed by Medicaid, because you will have to provide bank statements. They will see that these consistent withdrawn amounts of cash are being taken out every so often, or whether it's consistently or it is large amounts. They're going to ask, what was that used for? If you can't provide receipts, if you can't provide proof that it was used for something that you were buying for yourself, then that's the issue. You can't prove that you were buying something if you're paying someone under the table, right? Because there's no receipts for that. And that also, if you're paying someone under the table, this isn't always the case. They may be reporting it on their income, but what it seems to be the most common problem for the payee in that sense is that they probably aren't filing it in their taxes, and that is a problem for them if they ever get audited. Buying large gifts kind of goes along with this too. So if you're saying, my grandson's providing care for me, I'm gonna buy him that new Mercedes as payment for that. Again, that's a divestment for Medicaid. So you want to be very careful about any sort of substantial gifts. You can try to argue sometimes that gifts you were not making those gifts in with the intent of not paying for your care. You didn't realize that you were gonna need care within the next 5 years, or you thought based off of your current health that you could make it at least 5 years from that gift. But if there's any concern at all, it's better to not make those substantial gifts. Talk with an elder law attorney before you do anything like that. And I never would tell anybody, don't ever give any gifts going forward ever again, because that's may not line up with your goals in life either. But you need to make the calculation ahead of time that, hey, if I make this gift, I'm aware that if I need Medicaid in the next 5 years, that will be a problem potentially. And I'm making this gift fully, informed that this might be a problem, but I'm going to do it anyway. I mean, if you're making an informed decision on something and then it comes back and creates a problem, that is what it is. But never make a gift substantially thinking you're avoiding any problems, because that is not an informed decision then, or not a well-informed decision anyway. One of the biggest concerns that we see a lot with caregiving child and parent being the person receiving care is they may claim they have an agreement, but it's a verbal agreement. Verbal agreements are not going to help you here, because you can't show proof that it was ever existed, right? You might even have agreed on very specific terms, but how do you prove that those terms were agreed upon if they were not signed by both of you and notarized, right? You then have, if you have that signed caregiver agreement that's notarized, you have traceable proof that we agreed on this date, and following that date, I can show you based off of payments and things like that, that yes, this was how we were calculating it. So it was in keeping with that agreement. We made sure that it actually was followed correctly. It's onerous. I mean, you have to show a lot of evidence for these things, but it is important that you actually can show that evidence to not create problems for a parent. I mean, the issue here is not that you're trying to defraud Medicaid by any means by being the child receiving payments from a parent that you're providing care for, but because that is a good or a service that you're providing to someone. You are helping out. So this is not to say that a child should not be paid for the care they are providing, but they should be calculating into those payments what happens if they need care, from a facility, can they pay for that care out of pocket? And if not, and they need Medicaid, are these payments going to create a problem? So the caregiver agreement is a way to rebut Medicaid's presumption that you are divesting money. You can show that you were legitimately providing care, that you had this agreement in place, that it was, fair market value, that you weren't, overcharging for it either, right? I mean, if I'm not a nurse or a healthcare professional in any way, and I'm charging double the going rate of what a visiting nurse's program might pay or be paid, that's not good either, because how am I going to make that even somewhat reasonable as a result? Okay, so I'm not seeing any questions come up, but with just again, if you do have any questions, if there was any reason you weren't able to participate in the Q&A function or it wasn't working for you, you can always email us at learnmore@hooperlawoffice.com or reach out to us to set up an initial consultation. Again, those are complimentary, so it doesn't cost you anything to come and talk to us. If you have a parent in particular that you are looking to provide care for, and you want to set one of these agreements up, that's a really good reason to come in. One of the things that we're seeing a lot of right now is people are actually, they were holding off going into facilities. They were holding off doing care planning and things like that because of COVID and concerns about kind of group homes situations, or I forget how the COVID relief bill referred to it, but congregated living, right? So people are starting to look into that again. So this is something that we anticipate really kind of being a huge demand in the coming months. So I would absolutely, if it's a concern of yours, try to set something up. So for next week, we do have our another long-term care topic. So what you need to know about planning for long-term care costs. So that's more of a broad topic than today's, but it is just as important. And again, with that potentially increasing demand for people needing care planning coming up in the next couple months or next year, for all of those people who were holding off, it's going to be a really good topic for you to watch. And then after that, the week after that, we will have estate planning and foster children. So this is a planning topic that is meant to be marketed towards people who are like fostering to adopt, right? So that is a really good topic as well. It's a really interesting topic. And those are all, again, every Wednesday at the same time as this webinar. So if any of those are interesting to you, please feel free to sign up. And then later in May, one of our later topics is planning for family cabin properties in particular, the types of issues that can come up with that. So thank you all for joining me today, and I hope to see you guys at the next couple weeks. And if you have any questions, please feel free to reach out to, like I said, at learnmore@hooperlawoffice.